and I serve notice to the other side.
Inclusion.
Inclusion.
All inclusions give.
Lordship, may I have your Lordship's kind leave?
Any other inclusion? Give.
Not of this
Just-
determination.
Not of this determination.
Lordship, I'm making an mentioning about a modification of your Lordship's order of a conditional order stay granted when the Lordships were in determination of the hearing of first appeal. So, Lordship, there is a
Modification application.
Lordships have passed it, so I cannot mention it in the regular division bench. I have served and come.
Yeah.
Auditor TDG shop. Lordship, I have served and come. I have intimated.
What is the modification?
Lordship, suit for eviction of a licensee. Suit was decreed, counterclaim was dismissed. The judgment data has come before this first appellate court, and there was a conditional order of stay, Lordship, passed by my lords. And Lordship,
Let it be taken up Monday.
When I may pray for an extreme indulgence from your lordships. When your lordships hearing WPST, WPCT, and other assigned matters. When if your lordship convenient to your lordships, take up 2 days WPST, 2 days WPCT, and 2 days, 1 day assigned matters. That would be convenient for us also, because same day WPST, same day WPCT, if segregate.
That you want separate day should be fixed for ST and separate day for CT.
Subject to your lordship's consideration, and 1 day for assigned matters.
Let us see what is the pendency. Let us gather the data. We'll gather the data and we'll see what can be.
Item number 1.
My lord, I am appealing for petitioner.
For the respondent, my lord. My lord, in this matter,
My lord, this is the matter, my lord. The petitioner is the son of a deceased railway employee.
Yes.
but
Then
My lord,
consent.
Lord, they approached their interstate labor working as laborer. They approached the principal bench of Delhi, CAT, and principal bench ordered for passing a speaking order on the divisional railway manager Srialda.
They approached the principal bench for what?
For retirement benefit of his father. His father was a railway employee, my lord, of previous rules. SC, this is called SRTFC staff. And he has served the railway, my lord, 37 years. And he died on December 1995, entered in service 1949, and date of superannuation was 31st January 1986. What happened, my lord? The allegation is he was suspension for substantial amount of time, my lord. And suspension order was revoked. And after revocation of the suspension order, my lord, that effect was not given. That your lordship finds the speaking order at page 9. It will clear everything, my lord. At page 9, will your lordship kindly come to page 9, my lord. It bears everything, my lord. Before the principal bench, my lord, no affidavit was exchanged, my lord. Only speaking order was passed. Right. Oh, acting, yes. আচ্ছা আচ্ছা তাহলে see, my humble submission is suspension order was revoked and that order was not served during his lifetime, my lord, and that benefit was not given prior to retirement, my lord. And my humble submission is railway is admitted that he was SRPF C staff. There is a pensionable scheme, my lord. Let the my lord, humble submission, let the railway file the affidavit, my lord, if your lordship kindly permits, my lord. That will matter.
No, the order is very clear.
Yes,
My lord, my lord, my lord,
Please, yes, we'll call upon you. Order is very clear. What will they file? They are not required
my,
to
my,
file it.
my lord, SRPF staff is admissible pension scheme, my lord.
Show us. Show us the SRPF staff is admissible to pension. Show us
Then I have to give
tomorrow, as paid, not today.
Yes, ma'am. Not আচ্ছা আচ্ছা
Item number 2.
Item number 2, Miller, I am appearing for the petitioner, Miller. It is a matter, Miller. এটা একটা আছে পরে দিচ্ছি আপনাকে it is a matter daughter is claiming compulsory appointment whereas son already been appointed, Miller. What happened, Miller? Father died. Both sons and daughters were unmarried, Miller. And mother applied for son's appointment, Miller. Page 24, my lord, circular of compassionate appointments, my lord, rules.
Yes.
My lord, my humble submission is that the circular says that at the time of death, both are dependents on the father. Both were unmarried. And mother parted with the son. Mother did not accept the appointment, my lord. My lord, in the cat, the limitation period, for the limitation period, merit has been not adjustment. This is my only point, man.
That's all.
Yes, yes, ma'am.
The father of
Number 3. My lord, item number 3, my lord, yesterday your lordship was kind enough to adjourn the matter. I am led by Mr. Dijodas Mukherjee, my lord. This week, my lord, he has some difficulty, my lord.
Sorry.
As your lordship.
Can't be done every day, sir. Start.
My lord, in this matter, my lord, we are challenging the order passed by the learned tribunal in way number, my lord, 149/2024, dated 8/8/2024, my lord. My lord, the respondents are the retired Chief Loco Inspector of Adra Division under Southeastern Railway. My lord, at the time of their promotion, my lord, as Loco
They are
Inspector,
claiming parity with the drivers.
no, as a running staff, my lord,
Correct.
but they are the stationary staffs. Now the thing is that, my lord,
Passed an order.
yes, my lord, my lord, what I am,
Passed an order.
what, my lord, I am submitting, my lord, the respondents are retired during the period of 1997 to 2021. And in our reply before the learned tribunal, we have raised the point of limitation. But they, and also we have relied upon several judgments. That issue was not considered by the learned tribunal.
Let us see what is the issue of limitation. Show us.
If your lordship kindly see our reply, my lord, page 182, my lord.
No, when have they retired according to
My lord, may I submit, my lord? During the year 1997 to 2021. My lord, they have filed their representation on in the year of 2023 after the order passed by the Honorable Supreme Court. Now they are asking for the benefit of additional 55% as per with the running staff. My humble submission before your lordship that at the time of their appointment as local inspector, they has been given the benefit of 30% add-on pay element. Even at the time of their retirement, my lord, they have been given another 30%.
What is your reply? What have you said?
My lord, 182, my lord, page number. Page 182, my lord. If your lordship kindly come to page 183 from paragraph 3.2 Roman I, my lord. We have discussed, my lord, the honorable apex. May I
Where
read, my
is your issue regarding the delay? Don't argue the same thing which is already settled by judgments. What are you to say about the delay? Where have you said?
Well, if your lordship kindly says a limitation as per section 21, para 3.1 from last 5 line, my lord.
Yes.
As per section 21, that is a limitation of Central Asia Tribunal Act, an application is maintainable on within 1 year from the date of cause of action. In this instant case, the applicant have filed the case after 6 to 20 years. As such, it is barred by law of limitation. Moreover, fence sitters have no right as it is settled principle as laid down by the Honorable Apex Court in several judgments. Now, my lord, we have dealt with the judgments. We have cited the Honorable Apex Court also not entertain cases which are barred by law of limitation. Some judgment order passed by the Apex Court are such and such. We have, my lord, from Roman paragraph, my lord, 1, 2, we have cited more than 6 judgment we have cited, wherein the Honorable Supreme Court has categorically held that if the there is a delay in approaching the Honorable Court, the application is not maintainable.
Not raised any issue regarding delay. Come to the cat's order. There is no issue raised by you regarding
My lord,
delay.
may I submit one?
No, you may not. Yes, you may not. Yes.
My lord, we have raised in our reply, my lord.
You may raise 100 things. If you don't argue, what the tribunal or court will do?
My lord, when there is a preliminary objection raised,
This is
that
not the
with
forum.
regard to this point. Now, another thing is, if you lord,
Yes.
my lord, for my satisfaction, my lord, may I submit. Now, the thing is, the moment, my lord, they have appointed as local inspector from the, my lord, running staff to stationary staff. Now, they no more remains as a running staff. If your lordship kindly consider relevant rules, my lord, wherein specifically mentioned.
That has been considered. We are not going to reconsider. That is not something which has to be considered. That you have already said their nature of work is static. They are not entitled to any additional pay. That we have already
If your lordship, last week, your lordship, Malik, kindly consider my paragraph number 18 and 20 of my writ petition, my lord. Paragraph number 18 and 20. Page 26 and page 27, 7, my lord, if your lordship kindly see. My lord, they will get, if this 55% will grant, they will get more than that with what is admissible to them. Because the running staff, what they are getting, my lord.
We are not allowing you to reopen the issue.
Because my lord,
Not allowing you to reopen the issue. Don't argue unnecessarily. You know it is settled. We are not the only judge. Other bench has also decided it. So we are not going to reopen that issue. It is settled by now. They cannot be discriminated. You have to grant them parity with the
my lord,
drivers.
what my submission is that there is no discriminatory, my lord. Similar issue, my lord, Madras High Court has considered, my lord, if your lordship kindly see page number 226. I try to, my lord, convince you for your lordship.
Discussed, determined and settled already.
If your lordship, as a last of my submission, if your lordship kindly consider these judgments of the Supreme Court, Honorable Supreme Court. Only last, more for my own satisfaction, my lord, kindly consider this. What the Supreme Court has held, my lord. Yes, local inspectors. My lord, this is regarding the point that no, this is the stationary post and running post that has been discussed, my lord, paragraph 9. The once they have shifted to this stationary post, my lord, leave my submit. They cannot get the benefit of that, my lord, running staff, my lord. My lord, already they have been granted 2 times.
Then you give us. If it is not about loco inspectors, don't give us.
No, it is not local inspector. This is with regarding to stationary post, my lord.
It is
To be
not-
very candid before your lordship.
That is not applicable.
দেখি জাজমেন্ট একটা দেখি কোনটা দিলাম একটা দাও একটা দাও না দিলে হ্যাঁ জজ সাহেবের অর্ডারটা ঠিক আছে কি করে আমি আমার সাবমিশন করেছি জজ সাহেব যেটা মনে হচ্ছে দেখো একটু সার্ভিসটা সার্ভিস না পিটিশন হয়তো বুঝতে পারছো পিডিউটি সার্ভিস না পিটিশন এই যে নামটা দিচ্ছে।
And railway authorities has already implemented in several persons, even in Southeastern Railway, my lord, 25 CLI has been paid, another additional 25%. Now, acha.
Grateful, my lord.
Grateful, my lord.
Item number 4.
Your Lordship, my learned senior Mr. Ujjwal Rai is appearing for the petitioner. Your Lordship, I am humbly praying for a short passover. Actually, he is on leg in court number 16, Your Lordship. Only a short passover. Your Lordship, only a short passover. Your Lordship, I can only visit Your Lordship with the short fact of the case, and my senior will. Your Lordship, here's the. Your Lordship, the petitioner was engaged in a contractual basis as a investigator by the respondent authorities, initially for 4 months, and thereafter it was investigated, Your Lordship. Your Lordship, uh, Your Lordship, the Ministry of Labor and Employment, Ministry of Labor and Employment, Your Lordship.
Sorry.
Your Lordship.
I'm so sorry, my lord. I was. I'm sorry, my lord. I have to have, my lord. Lord, here, the point, my lord, for which I have just come before this honorable court is my application for recalling of, my lord, the order of passed by the learned tribunal. Against that order, my lord, have come. My lord, what happens, my lord, I filed a case in 2016. My lord, that case was my learned advocate was appearing for myself, my lord, before the learned tribunal. My lord, he said in 2021, when this matter was taken up, that the already issue is already infructuous. My lord, kindly, the issue is infructuous. So, noting the submission of the learned lawyer, my lord, the matter was dismissed as infructuous. So immediately thereafter, my lord, I came to know within 3 months of that matter was infructuous at the behest of my learned lawyer. So I made the application for recalling. I started appearing in person. Yes. That is, my lord, the application for recalling, where, my lord, in paragraph number 4 and 5, I specifically stated that I never instructed to my learned lawyer, nor the situation is such as has been submitted by the learned lawyer. So I prayed for recalling of the order. So this recalling application, my lord, was taken up, my lord, in 2024 by the order impute. So where, my lord, I once again appeared in person, but instead, my lord, hearing the merit on the recalling application, whether I instructed to my learned lawyer, what was the situation in the case, the learned tribunal took into consideration, my lord, the submission of the respondent Union of India, and said that at the belated stage, this could not be done. But, my lord, kindly take note that I filed the case within 15 days of the publication of the panel. I filed the recalling application within 3 months, my lord, from the date of the order is passed. So, my lord, there is no delay on my part. So, on this technicality, my lord, I was not permitted to place matters on merit, and, my lord, it was dismissed expressly. So, I just wanted, my lord, to be before this honorable court so that I could at least place my matter before the learned tribunal on merit.
Tribunal has considered on merit.
Yes.
Now, my lord, that is the difficulty, my lord. Here, lordship kindly sees
Has
what
appeared in person and the tribunal has
Yes.
considered on merit.
Yes, I appeared in person, and, my lord, the tribunal, lordship kindly sees that. May I place, my lord, to part of the learned tribunal's order? Because that particular day was fixed for hearing the recalling application. So I was minding, my lord, be that as it may, what was I thinking? My lord, here it says the learned tribunal's order. My submission about the that I did not instruct, subsequently month of June came up.
That is over.
That is there.
Come
So
to
on the other hand,
second last paragraph
Yes.
of the first page.
yes, on the other hand, learned counsel for the respondent, Mr. Sharma, brought the knowledge of the tribunal here that in a way the applicant had prayed for issuance of the direction of the respondents to appoint the applicant for the post of investigator grade 2 after taking into account the service he rendered for the same post and for taking into account the service and for further direction to re-evaluation of the reassess the marks given in the interview held on such and such and the result published in 2016. In the said original application, the respondents have filed the reply wherein it has been explained that the applicant herein had participated in the recruitment selection process and remained below the merit. Accordingly, he was not recommended for the appointment. As such, after participation of the selection process, it is not open for the applicant to challenge the said process since the applicant's case was considered by the respondents. He faced the interview as well, but remained below the merit. The tribunal had passed the order that the way has become infructuous since the selection process was concluded long back. Since the applicant did not receive any satisfactory response from the learned counsel, he intends to appoint another advocate on record to conduct the litigation and sustain this MA and thereby praise for recalling of the order such and such. As noted herein above, he admits that he participated in the recruitment process, but his grievance is that his credential was not assessed correctly. we do not find any substance at belated stage to accept the same. Accordingly, the MA stands dismissed. So, my lord, about this delay part, as I was addressing to your lordship, the panel was passed in 30th of June 2016. I filed this original application before the learned tribunal in 3rd of July 2016. So within 15 days, I did not make any delay, my lord, in making the application. So after that, my lord, this the at the behest of my learned lawyer, my lord, that matter was said to be infructuous and dismissed in 2021. So I came to know after, my lord, 2.5 months. Immediately after I come to know, I filed this application for recalling. So, my lord,
What is the advertisement?
yes, my lord, the advertisement your lordship will see, it is annexed in my original application. So I tell you lordship the page. My lord, page number 5, I'm sorry, 67, my lord, is the panel. I tell you, take your lordship to the advertisement. Yes, my lord, I'm grateful to my learned friend. Page 61, my lord, is the notice. My lord, has page 62.
So he was applicant for which post?
My lord, page number 62, my lord, of the advertisement, investigator,
Grade 2.
grade 2.
Investigator.
My lord has seen, my lord, the EQ, essential qualification. There. One of them is certificate course of coroner such and such. DQ, 2 years experience in collection, compilation, analysis. Apart from me, my lord, nobody was there having this experience in the entire.
Yes.
My lord, and Lordship has seen, my lord, the essential experience, my lord, essential requirement is one of them is experience for the last 2 years. And my lord has also seen, my lord, that in 2010 initially I joined as a contract investigator. And my lord, I have been performing my duties, and I have, my lord, also
In April 2010.
Lordship. So, my lord, I have also, my lord, annexed the certificates, my lord, which I gathered from the department, which is from page number 55 onwards, where each year I have been said to be outstanding or excellent in my performance of the duties.
How long you continued?
But 2016, my lord, from this record, my lord, I see that I got the certificate up to 2016. But I, my lord, cannot assist your lordship, my lord, whether I have been still working as contract or not. The page number 59, your lordship will see the last experience certificate is annexed. It is said to be an outstanding performance. Page 59. So my contention, my lord, before the learned tribunal, though I was not given the
Not
opportunity.
continuous. This is intermittent.
Yes, my lord, from 50.
4 months in 10.
Yes,
then in 11,
55.
6 months. And
Yes,
then
my
in
lord.
12, 13, another period between December to 6 months.
Yes,
in
these are
between.
the
So it
certificates.
is
my lord.
intermittently you have worked.
Yes, these are
Not
the
a
certificates.
continuous. And this is also on contract basis.
Yes, on contract basis. Absolutely, my lord.
Yes.
So this is about the experience I was trying to impress upon your lord. So I, my lord, also was not given the opportunity to file the rejoinder, my lord, to the before the learned tribunal, taking these points as well.
What point?
And that apart from me, my lord, there is nobody else.
Oh, that is not your case.
Yes, that problem
That
is
is
this, my lord,
not
that
your
was not
case.
make out. Yes, that is not there in the pleading.
That's not your case.
That is not there in the pleading, my lord, I admit.
Marks they have published which shows that you are below
The merit list.
merit list.
On the basis of the, because this merit list, my lord, comes with the written examination as well as the performance in the interview process.
There is no
So
such
I
case
said, my
made
lord,
out that there is nobody else having experience.
yes, it does not disclose from the pleading. But I was not also given the opportunity to use the rejoinder before the learned tribunal.
What is there in the reply? We are not even looking at the reply. We are looking at your documents only.
But since they have taken this contention in the reply, I ought to have been the respondents.
What?
That you have been the person who has been, my lord, less in
No,
merit.
they are not taking that in their reply. That is apparent from your own annexure at page 49.
My lord.
That is not a point raised by them in the reply. You
But,
have not made out a case that you are the only one who is having eligible.
But I did not. I admit to your lordship, my lord, that I did
occasion.
not make this case, my lord, in my writ petition.
Then
But
what can
good,
be
bad,
done?
indifferent, my lord, I did not. So, my lord, I just beseech your lordship, my lord, if I would have been given the opportunity,
Now we have heard everything.
my lord, if I would have been given the opportunity to take on record,
Find that it has, you cannot make out a new case by way of a reply or rejoinder. The law is very well settled. You
But
have not made out a case that you are the only person having eligibility. You are saying why I have not been appointed. That is all.
my lord,
OA does not say anything. Why you are challenging the appointment of the other two persons is also not apparent.
Right, my lord, in the original
you-
application, my lord, I just said that
I
there have
have
been
to be
bias.
appointed. I
There-
have to be appointed.
No, apart from that, there has been bias that I was not taken into
And there are
consideration.
two people above you. You have chosen not even to implead them as a party.
So, my lord, I
Cannot be granted to you.
because if I could have at least, my lord, given the opportunity to
That
place
we
my
have
case before
understood
the.
what you are saying.
So otherwise, my
Find
lord,
any reason for giving any.
Only apprehension of bias, nothing else.
as your lordship.
The petitioner
number 5.
That illegality cannot be considered in a registration. Yes.
This matter I am for the petition.
Oh, we have decided that matter yesterday. Same.
But basic
No, sir,
difference,
that
basic
different,
date of appointment 12 February 2009, discharge on 31st March 2009, and is a lump collection.
Allow.
We will. Your lordship, I see the page 60.
Yes.
For my satisfaction, my lord.
Yes, yes. That is what we are here for.
60. That is P3. The notification, your lordship, I see. Subject. Recruitment of female warder in correctional home under Domnom Central Correctional Home. The requirement. Category.
What is the distinction between this case and the case we have?
I'm placing. Distinction between, my lord, only my fault. I am not prepared. Your lordship, I see. I am now gather some information. The page,
Yes.
page 60, my lord. This is the requirement. Your lordship, I mark it age. Only 2 page I will place.
H.
Age.
At page 60.
18 to 27.
Oh no, which page you are reading?
Your lordship, page 60. Annex
P3.
T3.
Yes. Where is H?
Requirement, my lord, category such and such. First category, it belong to first category, not hill and woman. This is the height, such and such, weight, such and such, minimum 8 pass from the recognized school. Then, my lord, age, 18 to 27. Date was issued on 7/3/2008. Then, your lordship, I see. We have taken the point, some other person, 7 to 10 were selected. Who were the selected? Your lordship, I see. Page 67. Serial number, your lordship, I see. 60, 61, 62. 68. Serial number. Alpona Paramani, Potesari, and Sonda Das. As your lordship got it.
Yes.
Then your lordship, Kailis. Page 61, 62, dekhe na? Then your lordship, Kailis. The last column, date of birth.
Yes.
Date of birth 1951, 52, 53. That is age 58. If it is 51 on 2009, age is 58, 57, 58, they have been selected. I have taken that point. No qualification. Even they cannot sign. Qualification 8 pass.
This is not the select list. This is the list where of those who are already working for their regular.
No, your lordship, what is the note? Your lordship, sees.
You please read at the top of this list.
Top of the, your lordship, sees. Top of the
List of extra
temporary female warder engaged in correctional home of West Bengal for
absorption in regular service.
Absorption.
So this is the list for absorption.
No, my lord,
This is because they were working.
because I have taken that part was not controverted. Your lordship, sees paragraph 9, my lord.
This is not they have not been recruited in the same process that you were recruited. They have been recruited much earlier.
How it is possible? The notification.
That is there, that has
No,
been
your
said.
logical is the notification. What is the date of notification?
Which notification?
Notification page 60. I have
That is the notification pursuant to which you have been appointed.
no, your logical is
That is not the
recruitment-
notification pursuant to which respondents have been appointed. They were appointed much earlier. This we
recruitment-
have considered yesterday.
No, recruitment for female warder.
Correct. This is a transaction by which you were selected, not the private respondent.
Some your logical is this is the recruitment female warders for Dom Central Jail.
Correct.
Order number such and such.
Correct.
Then your lordship, this is the requirement. Dom correctional, Kishnagor such and such, all the correctional home.
Not required, sir. They were selected
Qualification?
much earlier. Much earlier. That list that you are reading is the list for their absorption because they had been working for such a long time. They were absorbed. You got selected in 2008 itself. Therefore, there is no question of claiming parity and absorption in 2009. That aspect we have
There is
already
not a
considered.
sheet of paper, Miller. There is no whispering that they were
There
selected
is-
earlier.
There is. We have taken note of that yesterday.
Your logical is the paragraph 9, Miller. I have stated. Such and such person, Miller. Your kindly see the paragraph 9.
Now, just a minute. Just see one paragraph that we are saying. Come to paragraph 7 of their opposition. We have considered this yesterday. It's nothing new. The same thing. It is wrong to say that the private respondents were not engaged by following the proper selection. They were regularized in 2009 on rendering service since long back before the year 2004. This we have considered yesterday, sir. They are not similarly situated as you. There is no question of claiming parity with them.
Not on rendering service except female warders since long back. That is a page
2004, yes. You are only selected after 2008 advertisement. How can you claim parity with them? You cannot. So same order has to be passed. We have passed that order yesterday. Yesterday we passed that order. Sujit.
But a correctional home is different. That's what Krishnanagar, it is would be Dam correctional home. এই যে দমদম correctional home.
আর কোনটা কোনটা?
Dam. Yesterday was the Krishnanagar. Date of appointment is 12 February 2009. Termination is 31st March 2009. Date of engagement 12 February 2009 and date of disengagement. Order.
I did yesterday.
That is not your lordship 287 of 2010.
So that we are taking up right now.
286.
So the correctional home name is different and a date of appointment is different. These two things. All right. Both these things will tally with the file. Same order. Yes.
This is Krishnagor, Nodia, তাই তো? আর দেখি হবে আপনার। তো কৃষ্ণনগর 289 টা কৃষ্ণনগর হবে সেম হবে কি সেম কোনটা জায়গা তো
Here is discontinuation is 1st April 2009. Is 10 of the keeping number.
Number 6 WPST number 289 তাই তো That is the superintendent of Krishnagore Correctional Home. আগেরকার মতো তো? একই? No, there is earlier four. One more. This is Krishnagore District Correctional Home. ওটাও তাই
But actually Krishnanagar.
কালকে তো কৃষ্ণ কৃষ্ণনগর একই কৃষ্ণ ফোর কৃষ্ণনগর বলে দিলাম তো আবার কি কৃষ্ণনগর বলে দিয়েছি দেখতে হবে না কৃষ্ণনগর
ওটা ফাইল করেছো?
কত এটা 7 দ্যাট ইজ অলসো কৃষ্ণ বলে দিয়েছি আমি জানি আমি কৃষ্ণনগর রেসপন্ডেন্ট দেখো না আমি
Item 8.
Item 8, recalling application. এগুলো হয়ে গেছে, এগুলো তো রিটে দেওয়া হয়েছে।
এটা রিকলিং, হ্যাঁ এটা
এটা তো রিটে দিয়ে দিই।
রিটে আছে, রিকলিং করেছি, রিকলিং
I've got preliminary objections.
number 8, ran for the applicant. But this is my application for recalling an order passed, my lord, on 1/9/2023, my lord. My lord. May I submit, my lord, the short fact of the case? But then, my submission is this, my lord. Our application has been, my lord,
To re-argue the matter. What recall? For what? You are aggrieved, you challenge it in appeal. You
Well,
go
we
before
are
the
not
higher forum.
we are not part-time workers.
We don't know. Yes, take down. Grant counsel for the petitioner.
Number 9.
Yes,
Lord, it is
may I
better,
present
I
it,
want to
ma'am?
know. Yeah.
I am for the petitions, my lord. My lord, what happened?
Because they have made a can application.
Because the
They have made a tendency of the read petition, they have filed a can application with.
and what happened, my lord, on the basis of a 2006 circular of the Railway Board in 2022, they have implemented and merging our seniority with the diesel loco pilots, which was
My seniority list will be published by the.
Yes, let me finish, my sir. Now, what happened, my lord? That we have challenged. We challenged before the learned tribunal. The tribunal initially granted stay. Ultimately, my lord, the original application was dismissed. The writ petition was moved, and there was an order dated 12/3/2024 passed by the coordinate bench that it would be placed before hearing for further consideration. Now, in the meantime, what happened, my lord? Following the impugned seniority list, they have published another seniority list, fresh seniority list, again, following the same seniority list, which is the subject matter of this can, page 61. Now, I could have prayed for my lord, before lordship, two seniority lists there in
Pendency of the writ petition, another seniority list.
following that. Again, they are
A consequential. It is a consequential. order.
consequential, but they are again
So
invited.
now you are challenging that also.
No, I am saying for stay or lordship. My humble prayer is that the writ petition is ready for hearing.
Where have you prayed for? Unless you assail that order, how?
That's the problem, my lord. That's why I prayed for stay. Because one after another, my lord, if they keep on
Stay has already been declined to you by the
no,
court.
of that seniority list.
So
That-
for every
no, my lord.
list,
But
you want us to pass a
they
separate
will,
order.
they would come and say that
We'll pass the same order again. Yes.
no, just a minute, my lord. I'm just let me.
Yes.
Would be a lossy pleasure to hear out the main application because of the fact, my lord, they will keep on publishing one after another seniority list and keep.
What can be done? There is no irreparable loss to you.
Yes, my lord, because
These issues don't give rise to an irreparable injury.
no, they will.
Once your seniority is set right, everything will fall in place.
No, if your lordship kindly consider that the writ petition may be hard out, my lord. And that is my humble prayer, your lordship. Writ petition may be hard out, my lord. Because it is after 16 years
All
there.
the pleading is on record.
Your Lordship, kindly see your Lordship's order passed by the coordinate bench. Yes.
Now, that up to that stage, it is on record. Now, this subsequent seniority list that you are challenging,
I'm not actually challenging, my lord, because I'm saying that
so you don't want to challenge that.
but you have a writ petition, I can freshly challenge. We have to.
Therefore, we are asking you, you have to make up your mind what you want to do. You want to proceed on this basis, or what do you want? Therefore, we are asking you. If you want to proceed on the basis of seniority list, which was challenged by you, we'll fix it.
Your Lordship, kindly fix it because same ditto
The-
copy.
Published, then I'm challenged that.
24.
25,
When it
Will
is
not-
taken up, you will make your submissions. Yes, call the next case.
After 20, this is the
Number 10.
reloaded.
Hello. হ্যালো সিরিয়াল 10 স্যার সর্বপ্রথমে আমি কোর্টকে প্রণাম জানাই, ডিভিশন বেঞ্চকে প্রণাম জানাই। স্যার 3/12 3/12/24 একটা কেস সেখানে পাস হয়েছিল। সেই কেসটার এগেনস্টে স্যার আমি একটু রিভিউ কেস ফাইল করতে চাইছি। তার জন্য স্যার আমি কিছু পেপারস এর আগে দিতে চাই। স্যার পেপারসগুলো যদি কাইন্ডলি আপনি নেন তাহলে তার উপর আমি একটু হিয়ারিং করবো স্যার। জাস্ট স্যার
আমি বুঝতে পারতি না বাংলায়।
স্যার 3/12 আমার এখানে কেস ফাইল হয়েছিল, মানে অর্ডার পাস হয়েছে। যে অর্ডারটার এগেনস্টে আমি একটু রিভিউ কেস ফাইল করেছি। পিরিয়ড 12 2000
We'll release the matter. Since you want to argue in person, we don't want to take it up because I cannot comprehend unfortunately. So we'll release this matter. You tell him it will go to some other bench.
ঠিক আছে তাহলে বলবেন রিভিউ তো।
These are review application alerts.
কিন্তু আমি অন্য বেঞ্চ বাংলা এখানে আমি নিজে বলতে পারি, তার জন্য আমি বলছি।
রিভিউ আমি যদি স্যার যদি পারমিশন দেন নিশ্চয়ই করবো। স্যার আপনি পারমিশনের সাথে অনুভূতি আমি স্যার যশ সাহেব আমি নিজে একটু কথা বলতে চাই মাই লর্ড। আমি তো অনেক হ্যারেজ হয়েছি, যার জন্য আমি অন্য বেঞ্চ আমি নিজে পার্সোনালি দাঁড়া থেকে কথা বলতে পারি, সেই ব্যবস্থা যশ সাহেব কাইন্ডলি করবেন।
Yes, yes, very good. The
দশ বছর সেই বেঞ্চ আমাকে পাঠাবেন।
we appreciate, no problem.
ঠিক আছে যশ, থ্যাংক ইউ স্যার, নমস্কার।
Item number 12, Mr. Ashish Kumar Choudhury, advocate, is appearing for the petitioner. He is engaged in court number 11. We have mostly completed the argument, Your Lordship. We are preparing the written notes of arguments. If Your Lordship kindly permit, we can file it on the next date. We are ready, making the written notes ready. If one day accommodation is given, we can file it.
Lordship, the matter is made returnable on
Monday.
Monday. Grateful. Your Lordship.
Number 13.
My lord, I'm praying for short passover, please.
No,
Lanet advocate's mother is in hospital, my lord. He's on the way. Kindly make it 12:45, my lord. He's on the way, my lord.
the issue, Mr. Mukherjee. This for the union.
He's come, ma'am.
I'm appealing. Well, there is also, my lord, in this matter, can application one was there, restoration application. But this he was misplaced, my lord. So I have no extra copy also, but I could not find that can application in this main application. Was the state appearing?
When it was dismissed in default.
Or due to non-appearance, when the
When?
matter was called
When?
dismissed in the year 2016, my lord.
We don't
And-
find any such order.
I filed, my lord, within time, filed, my lord. I filed the application within time, my lord. The order was reflected one order, my lord, at that time.
Can 1031.
Only one can.
Can 1031 for
Yes.
restoration.
Yes, my lord.
You have served a copy.
No, my lord. Don't have the copy, my lord. A total brief was dismissed.
Since 2012,
Yes, my
there is
lord.
only adjournment in this matter.
My lord, at that time.
For the last now 13 years,
Yes.
there is repeated adjournment at your behest on every date.
No, my
And
lord.
then there is non-appearance on 2 dates, and on 3rd date dismissal in default.
My
If you're
lord.
not interested, then why do you file such writ petitions?
No, my lord, at
To
that.
keep it pending for more than a decade. Even now you have not served a copy of the application. You have no intention of doing the matter,
No.
obviously.
No, I mentioned the matter before the respective judges, my lord. In the year 2016, 18, every time. My lord, the matter did not came in the list.
And
at
now
that
when
time.
it is on
But
the list,
after-
in this bench also, this is the 3rd occasion when it is having to be
Yes,
adjourned.
yes, my lord.
It
Yes.
appears you have no interest in this
No, no,
matter
no, no.
whatsoever.
No, my lord.
That
This
is what appears from the pattern of orders in the matter.
No, my lord.
Proceed with the can. We'll allow it. Come to the merits. Let us see.
Yes. Actually, my lord, can you come to page 23, 24,
Yes.
running page?
More than 10-year-old matter. So
that is it.
casually
Yes,
you are
casual,
taking it.
Yes, casual.
It is really very casual. Very casual approach, unfortunately.
My lord,
There's no seriousness on your part to pursue this matter.
my lord, petitioner
What
was
petitioner,
working
sir?
under
This is
under
not the way. We have also been there. It's not that we don't know. The approach is writ large from the order sheet. 13 years,
Yes.
only adjournments or default in appearance. And then you say you have not served a copy. Earlier we had mentioned everything you are saying.
My lord, before the Honorable Justice Matre at that time, the matter
Forget
was
the
heard-
history. We are telling you in this bench, this is the 3rd date.
heard.
Why are you raising that irrelevant thing which happened in 2016?
I appreciate, my lord.
Last date indisposed. Today again adjournment was prayed for. Don't want to do the matter. It is quite apparent. You just want to keep it pending. That is all.
No, my lord. No, that is not my intention.
That's
my
the
lord.
impression we
That's
get
not my
from the
intention, my
order
lord.
sheet. That is the impression we get from the order sheet.
Petitioner is working under the Geological Survey of India since 1976.
Who was the counsel appearing prior to dismissal in default for the Union of India?
Counsel appeared in the Union of India. I served the copy also to him.
Just now you said you have not served. Now you are saying you have served.
No, I served, my lord.
We asked you, you said no. Now you are saying yes. You don't know what you have done.
In the last occasion, they also appeared, my lord.
Where is the service? Show us.
Service also filed, my lord.
Huh?
Service, video service also filed.
Of the can?
No. Affidavit of service also filed, my lord. And it was heard in full length, my lord, before the Daden bench, my lord.
Sir, the order sheet does not disclose any such hearing. In the initial stage, there is one order for opposition. Next date, opposition filed. Thereafter, continuous adjournments, one-line orders. 2 non-appearance, 1 dismissal for default. Thereafter, before this bench, this is the 3rd date when again an adjournment was sought for.
I'm not paying it.
Quite disturbing. Quite disturbing. People are queuing up for having the matters expedited, and you are just allowing it to remain pending for more than 13 years. No seriousness on your part to take up the matter or to argue the matter. Can you have filed for restoration? You have not served a copy.
Served the copy, my lord. They appeared also.
Please, sir, just now you said you have not served a copy of
No,
the
copy,
can.
copy served. Everything is served.
That
And
copy
also,
served, matter dismissed. So now that counsel is bound to appear. Or you have to serve a copy of the can. You don't know.
no. Can also serve, my lord. And there
Just now said you have not served.
no, can serve.
Show us where is the service. Can service of
Service also filed, my lord. Or maybe that service also maybe misplaced with the total brief, my lord. That
maybe
is my
everything
fault.
will be lost.
That is
If
my
you
fault,
just
my lord.
procrastinate for more than a decade, this is what will happen.
Now, very recently, the file is misplaced within the.
Where is the service? Give us the detail. Who you have served it on?
I served the copy, my lord.
Just
If your
making
lordship,
submissions in here.
So if your lordship kindly allow me to
Anything.
serve again, I may serve the notice.
Again,
also.
what? Show us the first service, then again will arise. Where is the first service?
The total brief is misplaced. That's why I am
Unique.
unable to show my lord at this situation.
Should be correct that we should follow the to serve this. Yeah. Just take down. Let a copy of the
Immediately. 2 weeks. 2 weeks. 2 weeks.
Item number 14.
May it please your lordship, I am for the petitioner. This case has a checkered history. First of all, I moved the tribunal for 2 reliefs. Page 12. Rule 83 to the best.
Yes.
No, first of all, I approach the tribunal for two reliefs. One is direction upon the respondent to pay the arrear of the pay and allowances effective from 25 January 1998, fixing the salary of the applicant at rupees 4,650, being the last pay drawn from the defense service. And second prayer is that direction upon the respondent to withdraw, rescind, and or cancel the impugned order, such and such dated 27/4/2002, regularize his service, considering the representation dated 6 June 2012, addressed to the Principal Secretary, Land and Land Department, Government of West Bengal. So two reliefs were prayed before the tribunal, but the tribunal has failed to consider those reliefs. Well, what happened in this case? I was initially appointed in the military service and worked there for 15 plus 3, 18 years. I continued service in military. Thereafter, in terms of my appointment, it was discontinued. Thereafter, in the year 1998, I was re-employed. Under the government on the post created by the government. If you will also kindly come to the page page 20, the names created post are to be filled up by re-employed of retired employees or as deputation basis. So 3 posts: land acquisition officer 3 posts, head clerk UDC 3 posts, dealing clerk
LDC 3 post. So posts were created. I was appointed in one of the posts. And my initial appointment is 98. Is hereby appointed in the interest of public service to the post of UDC on contract basis in the office of the Special Land Acquisition Officer, North 24 November, on completion of landers. The post is created by GO number such and such issued by the Deputy Secretary to the Government of West Bengal, Land and Land Reforms Officer on contract basis for a period of 1 year on the existing terms and conditions. He will draw a monthly honorarium equal to the last pay drawn by him, less the pensionary benefit allowed to him by the Accountant General West Bengal on final settlement of pensionary claims. Overdraw, if any, will be adjusted against the final settlement at pensionary claims. The date of joining will be 26/10/98 in the office of the Special Land Collector. Initially, I was appointed in the year 1998. And my payment was, he will draw a monthly honorarium equal to the last pay drawn by him, less the pensionary benefit allowed to him by the Accountant General, Government of West Bengal. Thereafter, I was continuing my service and getting salary without the pensionary benefit. Thereafter, this appointment was modified. Page 39. Sri Kullan Kumar Bandyopadhyay, ex-serviceman re-employed for Rajarhat NTP, is hereby allowed to be fixed at rupees 4,000, being the minimum of the UDC pay scale of rupees 4,000 such and such, with effect from 26th October 1998. That is my initial appointment. In terms of Rule 83 of the West Bengal Service Rule, Death Cum Retirement Benefits Rule 1971, read with notification number such and such, ignoring the pensionary benefits up to 30th June 2004 for the present in supersession of previous appointment letter number such and such dated 25th October 1998. This order is issued post-dated as per approval of collector dated 21st November 2000. My initial appointment was modified by the order dated 30th August 2003 by the collector in supersession of the previous appointment letter. So my pay was fixed at the minimum of the UDC, that is 4,000, ignoring the pensionary benefit. So I was getting the last pay which I was getting from the military service, that was ignored, but it was reduced to 4,000. That means I will get pensionary benefit also. Only ignoring the pensionary benefit, but dearness allowance and other things I am entitled to get, and monthly increment I am also entitled to get, as I am a regular employee of UDC, starting from 4,000.
Yes, DA and increment, and you also want regularization.
Yes, yes, two pair. Well, I can tell you,
The prayer is based on what provision? Where do you get the right for the grant of these relief? From where do you get the right to obtain this relief?
from the order dated re-employment 20th August 2003.
Yes.
You will also kindly see. Sri Kollan Kumar Bandyopadhyay, ex-serviceman, re-employed for Rajaharat NTP, is hereby allowed to be fixed at rupees 4,000 being the minimum of the UDC pay scale rupees 4,000 to 8,850 with effect from 26th October 1998. That is my initial appointment. In terms of Rule 83 of West Bengal Service Rule, Death cum Retirement Benefit Rules 1971, lead with notification number 4th August 2019 and dated 14 September 95, ignoring the pensionary benefits up to 30th June 2004 for the present in supersession of previous appointment letters 25th October 1998. This order is issued post-dated as per approval of the collector dated 21st November 2000. So, my lord, here my pay was fixed as a pay scale according to the UDC. So I am entitled to get my all dearness allowances. My appointment letter dated 20th August 2003 provides for regular UDCs like UDC employees. I am entitled to get dearness allowances and other increments, everything.
That's all.
No, everything I am entitled to get. No, as I was getting, I made a representation. Thereby, page 50, your lordship kindly come.
Yes.
Statement of excess withdrawal of in respect of dearness allowances of re-employed officer and staff attached to new township project. Serial number 14, Kullan Kumar Gondopadhyay, just below middle, 14, 9,075. Excess amount drawn, 9,075. That is regarding dearness allowance. He has no power to deduct that amount. In terms of my appointment, 28th August 2003.
He has no power to deduct.
My lord?
He has no power to deduct what?
The dearness relief.
When it was given to you?
No, as per order dated 20th August 2003.
Dearness relief was given to you?
Yes.
Where we don't find it in the 20th August, we don't find that.
But your lordship kindly go through that appointment letter. It is like a regular employment.
We are asking you when you were granted dearness relief.
From that date.
You have been granted?
Yes.
You have said in the OA?
Yes, yes.
Let us see where you have said in the OA that you were granted dearness relief.
On my representation, I have stated. Several representations. One representation.
When you were granted, we are asking you when you were granted. You said it cannot be deducted.
Right.
One thing can be deducted only
If
after
it is granted.
So when you were granted, let us see when you were granted.
Granted from the initial payment, initial appointment.
Show us anywhere that it mentions that dearness is also being allowed to you.
Order dated 20th August 2003.
That is right before us. We don't find anything like dearness being given to you. 20th August is right before us, Annexure D.
Yes.
Page 28.
Page 39.
In which representation you have said that DA was granted to you? Show us from any representation.
Yeah. No, okay. Hello.
And where is the order stopping the dearness? Show us when it was granted and show us when it was stopped.
It was stopped. I have shown to your lordship.
We have not seen it.
Page 50. 50. Page 50, your lordship kindly say I have shown to you. Page 50. Statement of excess withdrawal in respect of dearness allowances.
Page 50.
50. Annexure E.
Our brief ends at page 49.
Paper book, by the way. paper book was 50. Because pursuant to the lordship's order, the paper book was prepared. When the appeal was admitted, I was directed to prepare the paper book. That is why paper book was prepared. It is central government. No, 14 is Kalyan Kumar Bandyopadhyay, 9,075.
Yes.
It was deducted admittedly, and my dearness also stopped from that date.
Yes.
And it was granted pursuant to a central government order, that is page 109, if your lordship can come. Your lordship kindly come. Paragraph subject recommendations of the fifth Central Pay Commission, payment of dearness relief to re-employed pensioners and re-employed family pensioner decision regarding. In terms of the existing order, dearness relief to pensioner and family pensioner is to be remain suspended during the period a pensioner or family pensioner is re-employed under the central or state government or in a statutory corporation, company, body, bank under them in India or abroad. These orders are also applicable to pensioners and family pensioner permanently absorbed in statutory corporation, company, body, bank under central or state government. Paragraph 2 is important. In paragraph 34.38.2 of the report, the Fifth Central Pay Commission has recommended that the dearness relief should be paid to the re-employed family pensioners and re-employed pensioners in cases where their pay is fixed at the minimum of the pay scale of the post of re-employment, ignoring the entire pension, and that in other and in other cases of re-employment, dearness relief shall be payable on pay plus non-ignorable portion of pension as the case at present. The Commission had further recommended in paragraph 41.12 that with a view to maintaining the original value of the pension, the payment of dearness relief should not be suspended where pay is fixed at the minimum of the pay scale during employment or re-employment of a family pensioner or pensioner. This order of the central government was issued on 20th, 2nd July 1999, on the basis of which the impugned order of 20th August 2003 was passed. So I was getting dearness allowance. রেগুলারাইজেশনে আসবো, রেগুলারাইজেশন ওটা দেখাবে পর।
Yes, for a brief period, some 8-9 months it was granted to you.
My lord,
For about 8 or 9 months it was granted to you.
yes, 9 months.
Yes, and not only you, all the persons working in that temporary office. It was granted to all the persons who were working in the temporary office, and from all of them it was withdrawn because it was a temporary office. It was not a regular office. It was an office fixed for a project only.
But there was a difference between myself and the other employees.
Yes, there is. There you are correct.
Yes, they were superannuated from their service, but I was not superannuated. If your lordship kindly come to page 51 of the paper book, my representation kindly consider. Page 51, application for revision of a decision regarding grant of dearness allowances and usual increments while pay fixed at the minimum of the pay scale of re-employed post. With due respect, I, Kullan Kumar Bandyopadhyay, dealing assistant ex-serviceman, have the honor to submit this application in continuation of my earlier application dated February 16th and beg to draw your kind attention that before attaining the age of 55 years, that is the age of superannuation, I was released from Defence Service, Indian Navy, at the age of 36 years on completion of my present terms of engagement, that is 18 years service, in the last post of rank of Chief Petty Officer Writer on Clerical Grade Secretariat Branch Logistic Department Organization, and with the last pay of rupees 4,650 and the amount of pension was rupees 2,405 per month. 2. After rendering continuous a long period of service in the new township project at Rajarhat, I had applied to you on 3/5/2002 the basis of memo dated 2nd July 99 of Ministry of Personnel Given Cell, Department of Pension and Pension Welfare, Government of India, New Delhi, for consideration of my entitlement of my salary in the post of UDC. However, the same was approved by your kindness on 21st November 2022, considering the various government orders. West Bengal Service Rule Orders of Finance Department, Government of West Bengal number 14 September 95, and a fresh appointment order has also been issued in my favor under order number such and such dated 20th August 2003 in supersession of the earlier appointment order dated 25th October 1998, wherein this pay has been fixed as rupees 4,000, which is the minimum of UDC's pay scale of such and such, with effect from 26/10/1998, that is from the date of initial appointment of pensionary benefit were not suspended. The pension and pensionary benefit were not suspended. From that order it will appear. Protection of pay does not reflect arise since UDC minimum pay scale for me present re-employment post is less than my last pay drawn. An area amount of rupees 1,10,500 on the basis of modified and refixed pay scale with effect from 26/10/98 to 30th June 2004 has also been paid to me. Accordingly, dearness relief, medical and house rent allowances, etc. All on a sudden, without any prior knowledge of mine, the benefit of dearness allowance has been curtailed, and excess relief which was paid to me has also been recovered from my meager salary. I drew your kind attention to my appeal, which contained in memo number such and such dated 2nd July 1998 in the Ministry of Personnel Public Grievances, Department of Pension and Pension Welfare, Government of India, wherein it has been stated in para 2 that with a view to maintaining the original value of the pension, the payment of dearness relief should not be suspended, where pay is fixed at the minimum of pay scale during employment or re-employment of a family pensioner, and the Director General of Resettlement, Ministry of Defence, New Delhi, ordered it states that once the initial pay has been
So you are
fixed,
relying on this memorandum of 2nd July 99.
Yes, Mula.
Where is that second memorandum? Which page?
110, 110 of the paper. Hmm? 110 of the paper.
This is the Government of India's memorandum.
My lord.
This is applicable to the state government.
Yes, yes, yes.
Where does it say that it is to be applied in respect of state government also?
But it was implemented. It was implemented. Your lordship can listen.
Where is the implementation?
I am saying. State government. Government accept
Government order দিয়েছে implemented. সেই অর্ডার কোথায় দিল? মিনিস্ট্রি অফ দ্য ডিপার্টমেন্ট গভর্নমেন্ট অফ ইন্ডিয়া কন্ট্রোল 115 সেন্ট্রাল অর্ডার থেকে
It was permanently absorbed.
Huh?
It was permanently absorbed, then this by 1990 would have been applicable because the language is permanently absorbed in statutory corporation, company, body, or under the central government or state government.
We couldn't hear you.
That this circular, 2nd July 1999, will be applicable in respect of the employees, ex-servicemen, those who are permanently absorbed in the state government.
From where do we get this?
Can you see the first paragraph, last sentence? First, in terms of the existing orders, dearness relief to the pensioner and family pensioner is to remain suspended during the period of pensioner. Family pensioner is re-employed, employed under the central or state government or in a statutory corporation, body, bank under them in India or abroad. This order also applicable to the pensioner and family pensioners permanently absorbed in the
So
statutory
re-employed or employed?
Yes.
Permanently, but
No,
it
no.
was not permanent.
These order are also applicable. Also. So first sentence I am entitled to get. Also applicable.
Hmm? Where is also?
Yes, Milo. These orders are also applicable to pensioner.
Fine. And family pensioner permanently absorbed.
Yes, permanently absorbed. Permanently absorbed.
Permanently absorbed.
Are also applicable to.
Correct. Permanently absorbed. That is the whole, obviously, if one is permanently absorbed, then that means all the benefits or all the components of the scale have to be given.
Yes.
The only additional thing is that because you are an ex-serviceman, they say that a portion of the pension may continue, or in some cases, they say the entire pension may also continue.
Yes.
That is the only additional thing you get by virtue of your service in the armed force. But the other components of a pay scale and all benefits attached to a pay, it can be extended only to a permanent, rightly appointed or permanently appointed government servant. Contractual people do not get dearness relief. That is why when it was given to you for 9 months, it has been recovered from everybody in the office. The entire setup was a permanent setup. It was to facilitate the land acquisition for setting up the new town. For 4 years, the office was set up. It continued for 14 years. Therefore, temporary staff was engaged and contractual, everything contractual. There is no question of grant of even the special land acquisition officer under whom you were working. Probably he would also not be getting the dearness allowance because he is also a temporary person. Everybody is temporary. There is no question of grant of any area.
No, I am working there for 14 years.
We have said that. We have
Yes.
just said that.
Yes, for 14 years.
14 years or 20 years, that's
No,
not
I
the
am-
point. Point is your status.
Yes.
Years is not relevant. What is your status? That is relevant. You are fortunate to get employment for 14 years. Look at it that way. Now the other thing regarding your
pub-
regularization, what is the provision? Where, under which provision you are claiming regularization?
Regulation. I worked there for 14 years.
In a contractual board.
No, no. It's not.
Your appointment was preceded by any advertisement or just like that?
That I don't know.
Must have said in your OA.
Because the posts were created 97. Posts were created and I was appointed 98.
No post was created, sir.
Yes.
No post was created.
Yes. Your Lordship kindly see.
Please read it again.
Yes.
Yes.
These posts were created.
Please read it again.
Yes. Page 35.
Yes.
Paper
read page 35.
I am directed by the order of the governor to say that the governor has been pleased to accord sanction to the creation of the marginally noted 42 posts belonging to different categories as
a special case.
As a special case
Yes.
and in relaxation of para 2, 3 of
For
the
a period of 4 years. Please read it in entirety. Don't read one line and make a submission. This was for a budgetary allocation to complete the land acquisition purpose.
No,
This is not creation of a post. This was a creation for 4 years. After 4 years, it was to lapse. Unfortunately for them and fortunately for you, it continued for 14 years.
No, that order was issued 97. 4 years.
Please read it.
Yes, 4 years. I have read it.
Yeah.
But that does not say that the appointment in the post will be abolished.
Oh, it does. It
No,
says.
no.
Read after
I
that.
am continuing up to
Please
12.
read after that.
Yes.
With effect from the date of issue of this letter, and the post will be abolished.
And by for a period of 4 years issue of this letter, and the post will be abolished after a period of 4 years on completion of acquisition of land project,
It
whichever
must
is.
have been extended till 14 years because the work could not be completed. It is quite clear what has happened.
So, that post was
Therefore, there
continued.
is no sanction of any post. There is no regular post. There is no regular appointment. There is no permanency whatsoever.
No,
Yes, we have seen that. That is why we are.
No.
We have seen the
Yes,
appointment letter.
my appointment letter is 20th August 2003.
No, it is not. Your appointment letter is at page
41.
No, this was superseded.
Contract basis for a period of 1 year on the existing terms and conditions. And 65.
Did you file any reply before the tribunal?
Correct.
Have you filed any reply before the tribunal?
Can you see that?
Good.
That is settled.
Rejoinder to the tribunal application, they have stated what is contract, what is the definition of contract, does not apply in my present case. In person to the order of the government, page 81, your lordship kindly come.
Page 145.
Sorry, 80.
87 and 88. Already filed.
Opposition at page 132. Paragraph 3. Page 138, paragraph 3.
পেজ হচ্ছে হাইট 87 আন্ডারলাইন করুন এটা 88
হাত দিয়ে রেখেছি।
87
What is rule 213 of the West Bengal service rules?
না এটা না ডব্লিউসি যাদবপুর বলে ডব্লিউসি দিতে 133 তো?
133.
Rule 120 to 143 was omitted.
Hmm?
The rule 123 to 143 was omitted.
No, 213.
What?
213.
Oh, sorry.
213 of part 1.
Yeah. 213.
That is the provision regarding appointment on contract basis.
Just give me one second. What is it? Part 1. Your lordship got it?
Yes, we have it. Just a minute.
Look, this is not applicable in my case. You'll also kindly come to Government Memorandum 87.
Yes, 213.
Hmm.
This is only for leave.
Leave.
That is for leave.
Can you see the rule one, ECRB rules, under rule 83(2), that has been mentioned in the order. Because he is an ex-serviceman, he will get a pension from the central government. But it is limited on state government. But cannot get two pensions.
No, I am not claiming two pension.
No question of pension.
Only regularization. When initial appointment is regularization.
He is not claiming pension. He is not claiming anything. He is only saying he wants dearness allowance, he wants increment, and he wants regularization. These are the three things.
First regularization, if he gets a regulation, then he will get increment. First
No,
he gets-
page 87, about regularization, your lordship kindly come to page 87 of the paper book.
What is that 87?
No, 87, his own rules has been superseded by the government order. 87,
What is it?
your lordship kindly see. 87 and 88, most vital.
Of the paper.
Most vital.
They are entitled to be appointed as a regular employee. That is a memorandum, Government of India Financial Audit Bank. For some time past, the state government has been following the policy of filling up non-PSC, non-promotional posts on contract basis generally for 1 year initially with the approval of the appointments committee of the cabinet. In each individual case, the contract appointment on those employees are also being renewed from time to time. Since, however, the job attached to these posts are perennial in nature, the above policy has been reviewed. On the basis of review, the governor has been pleased to decide as follows. The non-PSC, non-promotional post in general may be filled up on regular basis with the approval of the Finance Department and the ACC. For this purpose, steps should be taken for filling up the vacant post following the usual rules and methods of recruitment. And number 2 is important. Your lordship kindly come. The governor has been further pleased to decide that the employees who were initially recruited on contract basis, following the norms, rules, and methods as applicable to the relevant
That
post.
is why we asked you, where is the advertisement? What is the process of your appointment? You have said nothing in your way. Without reading this, we asked you, where is the advertisement? Where are the norms? Where are the norms of appointment? You have not said anything on that point. This is a settled law regarding regularization.
Advertisement. This letter I got from the Jela Report.
Hello.
Which provision in DCRB, Mr. Mukherjee, you are reading 83? 183.
183.
No, only 83.
83.
Military pensions. If the pension, but because he is not entitled to pension, rule 55, 88, 88, 55, capital T. Yeah.
83 2.
A2. And that has been mentioned in page 133 of the paper book. Okay.
You have not reduced.
No, we are not reducing the pension.
No, you have not reduced his basic pay by setting off the amount of pension. That you have not done.
No.
So 83 2, what does 83 2 say?
Can you see page 133 of the paper book? Third copy has page 134.
133.
133.
134 is the eligible copy.
Eligible copy is 134. For protection of the state of freedom.
So this entails that there is no pay protection.
And his appointment was contractual wages.
He is to be re-employed and draw the pay scale in the prescribed scale of the scale in which they are re-employed, irrespective of what was his salary there, scale there. And the second one is that if the pension is ignored, then his pay will be fixed at the minimum of the scale of the pay to which he is appointed, like it has been done in this case. Then, where's the question of giving?
And there is no such post facto approval. There is no such provision for post facto approval.
No, but why did you grant him that dearness for 9 months?
Because it was, but can you page?
That is perhaps why he is of the opinion that he should be getting it.
Page 50.
No, you say excess drawal. What do you mean excess? Why did you give it to him? This has not been recovered.
Yes, recovered.
Recovered.
Yes.
From 2006.
আর এটা টাউনশিপটা যতদিন চলেছে ততদিন ওর কন্ট্রাক্টটা
Total number of
টাউনশিপ
only for a township project. Only for a project. New township or new town.
So that we have seen, but why did you grant the dearness?
Yes.
Why?
Because sometimes I see that you should not enter mistake that have been corrected.
অপোজিশনেও বলা আছে
Now, in my case, 23% were there.
Yes.
23% were there. Yes.
All of them.
All were ex-servicemen.
ইয়ে সুপার হ্যাঁ এক্স সার্ভিসম্যান সবাই
You are the only ex-serviceman. Others are perhaps re-employed
সবাই রিটায়ার্ড অল আর
government servants.
ইনি শুধু সেন্ট্রাল থেকে এসেছে বাকিরা সব স্টেটেরই রিটায়ার্ড
No, all are superannuated. Yes, my all are superannuated except myself. Except myself.
You are also retired.
No, I am not retired. At the age of 36, my appointment with the military service was not given effect to, because that was tenure basis appointment. 15 plus 3, that is 18 years of service, military service.
Short service commission.
Yes. Though superannuation is 55 in military service. At the age of 36, I was No, if your lordship kindly come to page,
Can you see the appointment letter?
No, that we have seen that.
no, so far as the advertisement is concerned, your lordship was asking me, no, I inquired from my client, no, he says that it appears from the creation of the post, no, that was informed to the collector. And collector has published that in that notice board, local notice board.
That is compliance with Article 14 and 16. What is the law?
Law is that
notice board advertisement is not compliance.
no, that is also an advertisement. That is also an advertisement.
No. Must be in a true newspaper.
No, sir. Law is well settled in this regard. For ensuring compliance with Article 14, it has to be widely publicized so as to afford an opportunity to all who were eligible. This way, only one ex-serviceman has come. If it was advertised, maybe 5 ex-servicemen would have come. Maybe, we don't know.
No, I was not alone because there were.
Anyway, that's not a fact on record. You have nowhere you have said in the OA that any advertisement was published, there was any qualification laid down. After examining the qualification, you were shortlisted. What was the recruitment process? You have not said anything. You have just said, I was retired, I was employed. That is all.
Yes.
There is no compliance with Article 14 or 16 as per your own case. And we all know by now, Secretary of State of Karnataka versus Uma Devi, the law is very clear.
Page 87, Uma Devi's case is not applicable in the present case because page 87, your lordship kindly come.
What is that page 87?
Your lordship kindly come.
What is it? Tell us. There is any exception to Uma Devi?
Yes. That is the government order, Audit Department, 26 September 2005. The governor has been further pleased to decide that the employees who were initially recruited on contract basis, following the norms, rules, methods as applicable to the relevant post.
Therefore, we are asking you, where are the norms, methods followed in your case?
Yes, it was followed.
Not at all. Where have you said? Where is the advertisement? Where is the qualification? Where are those things? By saying yes, it will not become yes. The facts have to emerge from your pleading. There is nothing in your OA.
No, that is not
retired, appointed.
No, that is not required because I was retired from military service.
Therefore, you can go anywhere.
Yes, therefore, thereafter I was given. You will also kindly see the other notice.
No, why should we go further? It says the appointment has to be as per norms. Where are the norms? See the norms for appointment under the service rule.
Okay.
There has to be a creation of posts. There has to be financial budget allocation. Then there has to be an advertisement. After the advertisement, laying down the qualification, everybody has to participate. There should be a recruitment process entailing
regular service.
Nothing is there.
That is regular service, not on contractual basis.
Oh yes, for contractual also.
Yes.
It is being done. Just ask him.
No.
Yes, for everything now it is done.
No, if you will also kindly come here, some relaxation has been given to me.
Sorry,
your lordship kindly come to page 88 also.
We have seen that.
88, that is a memorandum of the government. 88.
How many times we'll see that? We have seen it already.
In continuation of this departmental memo number dated 26/9/2005, the undersigned is directed by the order of the governor to say that the decision of regular appointment against regular vacancies under the government in respect of those employees who were initially recruited on contract basis.
There is no regular vacancy. There is no regular vacancy in your case.
No, who were initially recruited on contract basis following the norms, rules, methods.
There is no regular vacancy in your case. It is a limited vacancy. It is sanctioned only for 4 years. It is a temporary vacancy. There is no regular vacancy.
No, 4 years not. I worked for 12 years.
14 years, not 12 years. You worked for 14 years.
14 years.
Yes.
If you will also kindly come to page 209, that is a government order. You will also 219, 219. Assistant Secretary to the Government of West Bengal Land and Reform Department is writing to the Collector District Magistrate. You will also kindly see. And I was regularized. That has been suppressed after the. Yes, that has been suppressed
Yes, show
after
us
the change of government below. I was sacked.
Where is the regularization order?
Yes, that has not been given to me. That is with them.
Then how do you know you were regularized?
No, I have come to know because after
Where-
the change of government.
Where have you said in the way? Show us.
No, that I can't say because
Make submissions in here, please. Confine yourself to the pleading.
no,
This is not an open.
without document I
This
cannot
is not
speak.
an open forum that you can say whatever you want.
Yes.
If you have said in the pleading, argue it. Otherwise, don't confuse
No,
the court and don't confuse.
let him deny that.
Sorry, sir. Where is the averment to be denied? This is not the way to argue a case. You will make a submission based without any pleading,
No,
and
you
he has
also
to.
come to the page 219.
We are having patience.
No,
That
I
does
will
not mean
support it.
we are having patience. That does not mean you will say anything and everything under the sun.
No.
You are a counsel. You should confine
Because-
yourself.
But supporting document is
Whatever he tells you, you will tell us. Whatever
290.
he tells you, you will tell us. What is this? This is the way to argue a case.
No, your lordship also knows. In
No
government,
pleading. What we know only that you will have to confine yourself to your pleading. This is not an open forum. You will say whatever you want. This is not the way to argue a case. We are examining things patiently.
No,
that does not mean that you will
219 your
that you will
lordship-
take undue advantage and waste the
No,
court's
sir,
time.
sorry for saying that.
Yes.
Yeah, I was regularized. Plus 219 is their own document. Your lordship
Right.
can see.
That you may show.
219.
Very well, we'll consider 290.
No, 219 your lordship
Yes,
can
we'll
see.
consider. We have seen it.
Regularization of service, etc. of Sri Kollan Bandyopadhyay,
Yes.
UDC, contractual attached to the office of the special LAO 24 Parganas. In sending herewith the memo dated such and such 13 July 2010, along with its enclosure, received from the Secretary Rajya Sainik Board, which will speak for itself. The undersigned is directed to refer to
Yes,
the.
we have read it. We have read it.
Please explore the possibilities of
We have
regulariz-
read it. We have read it. We are saying we have read it. We have seen it.
Dismissal order. Dismissal order টা কোথায়? হ্যাঁ?
Yes, that is all.
No. One document I want to show to your lordship,
Yes, show
which
us.
is not part of the paperwork.
Sorry, we are not going to see it. Anything else from the book?
Yes, ma'am. Your lordship kindly see the. কোথায় গেল ওই হারিয়ে গেল ওইটা? No, 2016. Page 2016.
Page 2016.
Yes. As directed by the Joint Secretary, Land and Land Reforms Department by its letter dated 21/2/2000, the following officers and staff who are engaged on contract basis for a LA work pending to various projects as mentioned below in the district are hereby discontinued on and from 2/5/2012 in the afternoon.
Yes. That we know.
But appointment letter was 1 month's notice is required. That notice is not there. Appointment letter, you will also kindly see initial appointment letter.
Yes, yes.
Terminated 1 month's notice from either side.
This is not a termination. You must be knowing that this is not a termination. This is not a termination. The work has finished. All the persons have been released. There is no question of termination.
Discontinue it.
Yes. Anything else?
As your lordship has already.
Yes. Yes, Mr. Mukherjee.
My service was, I rendered 14 years service to the
14 years, you need not say 14 times.
Then I have to close my mind. As your lordship has decided your lordship's mind.
No question of repeating the same thing 10 times, sir. There is no point in repeating the same thing 10 times. Yes.
Appointment for the page. 41.
Yes.
In the order. Dated 25th October 98, 26th October 19. The Koldan Kumar Bandapade ex-serviceman officer thereby appointed in the interest of for the post of contractual basis. The post is then paragraph 2. The post is created by the or by the deputy governor on contract basis for a period of 1 year on the term. If draw the monthly revenue will be last for eventually benefits allowed by the accountant of 100 segment. The service is regulated by 30 targeted without assigning after serving 1 month. State mana
13. 13 does not apply. Why does it refer to Rule 213? That is why we are asking you.
213 mala leave is concerned.
Regarding leave.
Leave. Although it is a contractual appointment, but he was given a leave.
Yes.
And there is no such. And so far as pension is concerned, I think he is not.
He is not asking for pension. Why?
Only regularization.
No.
No.
He wants dearness relief, he wants increment, and he wants regularization.
Yes. First one is regularization is met, then settling.
No, he says for this period also, whether regularized or not regularized, he should have been given his dearness relief and increment because you have given it to him and you have withdrawn it after giving it to him for 9 months.
Yeah.
That is one part of his submission. The other thing is that since he has worked for 14 years, since he was continuously discharging his duty, therefore he should be regularized in terms of the government's recommendation.
And so far as dearness allowance is concerned, that he is not entered. And he accepted it. When 2006 order was passed,
But you paid him dearness allowance.
yes, but subsequently detected the mistake by politics, we have recovered.
So is there any order granting the dearness allowance to him?
No. You paid, the office paid him, then subsequently detected that he is not entered.
There is no order directing for payment. It has just been paid like that. No order.
They do not find one. But so far as the price is concerned,
But increment has never been paid. Only dearness was paid.
there is no such provision in our rule.
No, we are asking you, was it the outcome of any order issued, or it was somehow it was just paid like that?
Usually paid, then it was detected that wrongly paid.
We have seen the order recording it, but we have not seen the order by which it was directed to it.
ওই জন্যই তো ও অ্যাপ্লিকেশন করেছে পেজ 51 51 এ আসুন রিকভার্ড হয়ে গেছে পেজ 51 পেজ 51 টা দেখুন এই তো বলেছে যে অ্যাপ্লিকেশন ফুনকশন অফ ডিসমিসাল ওকে তো অলরেডি ইয়ে করে দিয়েছে সেই জন্যই তো ও বলেছে যে আমাকে এই করে দেওয়ার জন্য
I think it's 48 for the moment. Page 48. Order dated 23rd February 2006. Then submitted for a necessary order for conveyance or recovery effective earlier due speed. Then there is an order. Mentioning here that the matter has been discussed in the and others in respect of a withdrawal of that, and they are submitting that the order of recovery to just accept. After discussion, this order and submitted for necessary order.
Here, this is not what we are asking you. There are two things. One, this is a file noting. This is not relevant. We will not look into this because only order has to be seen. We are asking you, is there any order for the grant of DA, or it was just drawn by them from the treasury like that? Read also. Can you read page 48, entire page 48? There is so much of black marks that it is not possible to.
The file looking.
As desired by order of appointment of she. It is worth mention here that the matter has been discussed with. Yes, recovery through installments. They will recover receipt. They will accept. Is there the order for condonations to recovery, whichever deems fit? There is no order. It is not said in the OA also. Anyway, anything else?
Partition for pay fixation was made.
No, partition is the last pay drawn.
Last pay drawn.
That is from military side.
Military side. On the basis of that, but this one was detected. This is the certificate submitted by the naval officer, example, this was deposited, then it was detected that it's not entered. And recovered from about 23%.
This must be from the treasury and the. Is it in- Somebody must be.
Now, can you see page 12, what was the prayer made before the tribunal? Rejection of the respondent, page 12. Paragraph 8. In paying the areas of pay and allowances effective from the applicant after drawn from the rejection of the respondent. 27th April 2012, discontinuing the service of the was in last 14 years after employment ex-serviceman in a regularized his service concentration dated. But there was no such prayer. No such prayer for page 12, before the tribunal. Only for discontinuation notice to be set aside and fixation of salary and regularization. Dearness allowance never separate.
Oh, so he is just in the prayer, he is only seeking the last paid drawn.
Last paid drawn.
No dearness or anything. But the
He has
tribunal
not asked for recovery of the refund of the amount.
he has not asked for.
In my representation, I have asked for. In my representation, I have asked for. The entire dearness allowance I have asked for in my representation.
The tribunal is to consider your representation or your OA.
No representation consideration by the tribunal.
Then tribunal has to consider your
No, I am challenging the tribunal's order.
Are you challenging your own OA also?
No, certainly.
Not, hopefully not. That he is referring to your prayer in the OA. Why don't you?
I think nothing can be said after that.
Then therefore there is no question for any dearness allowance, or it's only question whether regularization is.
This my learned friend was doing his part that I have not disturbed him. I have seen the prayer made and what is that?
All argument has been made with reference to arrears of dearness allowance, and all argument is being made for
total new argument will be put.
No pleading and no prayer, and still we are
and no documentary
wasting so much time.
Pleading is there.
No, the single lines reading is there in the original.
Just take down. Yes, you want. Come to page 12 of the paper.
My lord, direction upon the respondent to pay the area of the pay and allowances effective from the initial date of appointment, fixing the salary of the applicant at rupees being the last pay drawn from the. My prayer is that my last pay drawn is 4,650, so that will be the initial payment, basic pay. And dearness and the area of the pay, that is the from 4,650 minus 4,000. That I am entitled to get from the initial date of appointment and the area of pay and allowances. That allowances means dearness allowances. That means dearness allowances.
Yes, heard land counsel for the petitioner as
Item number 15.
Item number 15, I'm paying for not today, my lord. Lordship, these are some information on the last occasion, my lord. We received the documents, my lord, yesterday, my lord. We have to go through the documents so that your lordship, we can satisfy your lordship more better, my lord. 1 day accommodation, I think.
Not today.
Deep level.
Item number 16.
Lord, Paparazzi. Lord, before your lordship takes up the matter, Lord, may I point out something, my lord? Lord,
No petitioner.
my lord, it's not the first time they are not represented. This matter has been dismissed for default previously also, at least on 2 occasions, my lord. Lord, may I point out something, my lord, with regard to the restoration part? I found it, my lord, subject to lordship's consideration. Your lordship will find an order in your lordship's order sheet dated 24th March of 2021, passed by the then division bench, my lord, presided over by my lord Justice Bindal. Well, in this order, the writ petition was dismissed for non-prosecution after recording a prima facie view why the writ itself is not maintainable. After recording that view, the petition was dismissed for non-prosecution. Now, my lord, in that, a can 2 was filed. Well, this can 2 was for restoration of the WPST. Since it was not in proper form, upon that being pointed out by the Honorable Division Bench, that can 2 was withdrawn. Order date table. Well, the can 2 was withdrawn by an order dated, it's recording an order dated
20th January
20th January. A can 3 was filed. This can 3 was dismissed for default by an order dated 14th of July 2023. 14th of July 23, your lordship will find in the heading that it is dismissal of can 3. Now, in the last order passed by your lordship in can 4, না 6 একটা অর্ডারও দিতে পারছিস না, খুলে রেখে কি লাভ হচ্ছে? 6th February, my lord, your lordship has been allowed, please to recall the order of 14 July 2023 because that was the prayer in can 4. Therefore, my lord, the order of the division bench presided over by my lord Justice Bindal still remains. Can 3 has to be first decided whether there is a restoration of WPST or not. But your lordship has been pleased to record that the writ petition is accordingly restored to its original file and number.
So what is can 3 for?
Can 3 is for restoration of that order because the
Of which order?
14th March 2021. 24th March 2021. 24th March 2021.
Yes.
It was dismissed for non-prosecution.
Yes.
Can 3 was for recalling of that order.
Yes.
That got dismissed for default by an order of 14 July 2023. Your lordship has restored the order, the can 3, in your lordship order of 6 February. But the order of my Lord Justice Bindal still remains, which is 24th March 2021, which has to be restored after deciding can 3, which can 3 has not been decided till date. And though my lord can 3 is can 4 is now decided, your lordships will find in the prayer of can 4 that they only wanted recalling of the order of 14 July 2023, not the parent order of dismissal dated 24th of March 2021.
14 July, so therefore it was for restoring can
3 only, yes. Therefore, there is technically no order in can 3.
Anyway, even if they are only if they are here, these things can be considered. Otherwise,
Malad, for Malad, this is Malad the 4th year running where they are not pursuing their matter, Malad. We are Malad being made to back and forth, Malad. This is a if dismissed for default today, it will be the 3rd time.
none appears for the petitioner. List on Monday.
To point out when they are here. Well, 10 March, I may not be there, Malad. I have no person review. My learned juniors will be there. Grateful.
Item number 17.
Your Lordship, I am for the petitioner. There was a direction by your Lordship to file a supplementary affidavit, which I was filing before your Lordship.
Where is the order passed in the earlier way?
Your Lordship, the order you asked for that, which was passed in 10th
970.
OA 970, your Lordship, I annex that, which is passed on 10th April 2017, and the next date is 12th May of 2017, which order is not in record or neither it's uploaded, your Lordship. But in the OA 1300 of 2017, that mentioned that OA was allowed for withdrawn, your Lordship.
So how have you said that it was withdrawn when there is no order?
As per the instruction of the client, your lordship, that matter was withdrawn, which was also
You know
mentioned.
that it was withdrawn. How can, that is why we asked you to place the order. How do we know that it was withdrawn?
This is also mentioned in way 130 of 2016 order that the withdrawn petition was allowed.
The impugned order.
Yes, your lordship, please came to on page number 49. Second para, your lordship. Here mentioned that the applicants were allowed to withdraw the way 970 of 2015.
While 970 was pending. So you filed this OA while the earlier OA was still pending.
No, lordship, that was not pending. That was withdrawn by the petitioner. After that, the 130 of 2016 was proceeding.
When was it withdrawn?
On the
12/5/2017.
no 12 had.
So 12/5/2017
But
when it was withdrawn, that means in 2016 it was still pending. Does it?
But the
No, but comes after that. If it is withdrawn in 17, that it means it in 16 it was pending. So in 16 you have filed this way. And that you say was withdrawn in 17. There is no order of withdrawal. have you done? And who was the applicant in that case? A different person. Ujit. Whether both were there or there also it must have been both. Subhajit.
Subhajit Goswami is the son of that deceased person. Petitioner number 2 here of your lordship.
Here and there, all you were also a petitioner in that case.
Rumi Goswami and Subhajit Goswami. Both are the petitioner on that matter.
Here you were not a petitioner. Huh? Correct, but in the earlier case only the son was.
In OA 130 of 2016, both are the petitioner, your lordship. In OA 130 of 2016, Rumi Goswami and Subhajit Goswami both was the petitioner.
Asking you who was the petitioner in the earlier way. Only your brother was the petitioner.
Yes, your lordship.
Now he filed an application for compassionate appointment. You say he has withdrawn it. Before he has withdrawn it, you have joined with him and filed another way.
In OA 970 of 2015, Subhajit Goswami is the applicant.
Here also he is applicant.
Yes, your lordship.
So how can he be? When one way is pending, he has filed the other. 970 was filed in 2015.
Yes, your lordship.
This OA he has filed in 2016. 970 he has withdrawn in 2017. So when it was pending, he has filed another way.
For this reason, your lordship, the tribunal allowed that.
So how it can be? You tell us whether it is maintainable. Regarding him, it is not maintainable. You have not approached before 2016. And your father has died in 2011.
12.
Then
It was 11, your lordship.
Then after 5 years, you have filed this way. Yes, we have seen that. What is wrong with the tribunal's order? And we asked you to show the order of 12/5/17. You have not shown the order. How it is possible that the order is not online or it is not available everywhere?
I found it, but I didn't found that in the record also, your lordship.
You did not obtain certified copy.
I applied for certified copy. I already annexed that, but I didn't find the last order, your lordship. It's neither on record also. But the withdrawn was allowed.
He has not stated that it was Let us see what the order is. You must show us the order of 12/5/17.
Your lordship, grant me 2 weeks time. I will try.
Why? That is why we had granted you time. Why have you not come with it? despite our order, earlier
Deeply obliged, Your Lordship.
Item number 18.
Should I appear for the Union of India? It's my petition.
অনেক কেস করেছে আবার একটু দাও। Well, my preliminary objection, this retribution is not maintainable in law. Because the order your lordship impugned is a agreed order, consent order. How the writ can lie against the agreed order and consent order? Statutory.
How this rule can be overlooked? Huh. Fine. 696 plus 95. See. Have been filed by Ganesh Thakur. Substituted by Veena Ratra. So, disciplinary authority. Cannot. What is substitute? Because it set aside. It's not the Yes.
Lordship, on the last to last occasion, your lordships had asked us to satisfy your lordship on why Rule 17 of the Central Administrative Tribunal rules read with Section 22F of the Act, which speaks about the review. Your lordship, because my review petition, your lordship, was dismissed solely on the grounds of limitation. This is on page 34 of my petition, your lordship. I think your lordship's pages are differing. This is the order of 4th of November 2019 in the review application, wherein your lordship, merits were not gone into, and it was simpliciter dismissed on the grounds that this is barred by limitation.
Yes, that is why we asked you. You have to cross that hurdle first.
Yes, your lordship. So, your lordship, I was also to provide certain orders of the review petitions, your lordship. So, I had sought instructions regarding the same, your lordship. And they had asked.
The review in the case of other person.
No, your lordship, the review order and the orders of the other OAs. So, your lordship, the department has not been able to obtain all the orders as yet, your lordship. So if the orders come, your lordship, once the orders are there, I can furnish the same, your lordship. They tell me that that will take another week. Since it's not on the website, your lordship.
Which order is required? We don't remember. For what purpose? See, you have, before the tribunal, he has challenged the entire proceedings. On consent of parties, it has been remitted to the disciplinary authority. Now you have filed a review. That review is belated, barred by limitation under the Act. So how the review can be allowed? Just tell us, you have assailed the review order or both orders?
Your lordship, I have assailed the order dated 13th of June 2019 along with the review order as well. Your lordship.
So both orders.
Both, your lordship.
You have to meet
But-
the issue of limitation.
Yes, Your Lordship, but in order to satisfy Your Lordship, I need to show Your Lordship all the orders. Now, those order copies, Your Lordship, they have not been able to obtain. They have asked me for another week's time, Your Lordship. So I will satisfy Your Lordship on that. And I will also show judgments wherein I will show that in my review application, merits ought to have been entertained.
Therefore, we are asking you, what is the relevance of the order passed in the other reviews? They are all barred by limitation.
Your Lordship, there the merits were gone into, Your Lordship. Which is why, even though it was barred by limitation, the merits were gone into, Your Lordship. That is what I want to show to Your Lordship. But they have asked me for another week's time, Your Lordship, which is why I'm humbly praying. And then I'll come back and satisfy Your Lordship.
Even if that be so, the issue here is the issue of limitation. Because the tribunal has considered some matter, therefore that will not be binding on us. You will have to still show us that this review is fit to be considered in spite of section 22F or rule 17.
Yes, Your Lordship, I will.
Let us see what you have to say on that. Which judgment you are relying upon? CAT's judgment is not binding on us.
Yes, Your Lordship.
Therefore, what other proposition? If we remember correctly, some judgment was cited on the last day. Don't know.
Huh. So, Your Lordship, there
is just being pending for no reason. Then let us see how you overcome the issue of section 22F and rule 17.
Your Lordship, it is imperative for me to show to Your Lordships that those orders.
Not required. We take it from you that yes, the tribunal has done it. So that will not be a binding precedent on us.
Very well, Your Lordship.
Let us see how it is, how you overcome the issue of delay.
Lordship, I will bring all of those judgments along with precedents that I wish to use to convince your Lordships regarding.
Not precedents for us. Please try to understand.
No, Your Lordship.
Less exercise.
I understand, Your Lordship. With all due respect, along with those tribunals' orders.
I don't want those tribunals' orders. You show us the law in this regard. How do you overcome the issue? That is all we want to see.
You kindly give.
Even if the tribunal has not considered, we may consider if you are able to convince us with reference to the provision or any other Supreme Court judgment or a coordinate bench or some judgment which is binding on us. What the tribunal has done, that will not affect what we decide in the present proceeding. It may have, it may not have. The point is whether you can or you cannot. Let us see.
Your Lordship, I will show those judgments to Your Lordship. Today, I don't have them with me, Your Lordship, but I seek very short date, Your Lordship, to come back and convince Your Lordship.
You are seeking adjournment. This is not the way.
No, this is the last occasion, Your Lordship, because the instructions did not come, Your Lordship. Therefore, it was not possible for me.
Not
But
something which is dependent on any instruction.
absolutely. No,
This is
he's saying it was pending for a long time. So earlier the
we are
instructions did
saying,
not
why
come.
do you want last day also we have adjourned it just like that? It can't be just adjourned on every day like this.
So this is the last occasion, Your Lordship. Lordship will give me a last opportunity. On the next date, I shall satisfy.
No review application or continuation application delay was, my lord, annexed with the writ petition. There is no review petition. No, my lord, the application for continuation of delay. Nothing is there.
Is there, sir?
It is there.
It is there.
But my lord, I have served already the writ petition. There is nothing is there.
Page 35.
35 is the, my lord, the order. Order of this order.
So Your Lordship's
Page 35 of the writ petition. See page 35. 35 of the writ petition. Memorandum of review. It is annexed.
My lord, I have got a copy. There it is reply on behalf of the respondent to the application filed by the applicant.
Page 35.
Also, can you see? There is no pejoration. Yes, page 30, that is page 36.
Why are you proceeding this way? You are not serious about your.
Your Lordship, I have repeatedly asked them to give us a uniform copy.
What is this,
As
madam? For your respondents, we'll keep waiting for.
Last opportunity, Your Lordship. I will personally, I undertake to.
Very unfortunate way of proceeding with the
I'm
case.
humbly requesting for the last opportunity, Your Lordship, because it's been very difficult. The officer had changed.
We are not concerned. That's not the concern of the court or the respondent.
So,
That is for you to sort out.
Your Lordship, repeatedly I have been writing to them, Your Lordship, from my end. Last opportunity, Your Lordship. Kindly.
I have got the judgment, two judgments of that.
The petitioners.
Should I?